Okay, this is the people of the state of Michigan versus Sonny Scott Allen, case number 253956 FY. Appearances, counsel.
Hey, cards on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Mr. Allen. He's joining me.
The court has requested this hearing today to bring everybody up to speed as to what's going on. So we took a plea back on September 24th to an attempt interfering with electronic communications. And when that gets put into the system, it's kicking back that it's a felony. So although historically it hasn't done that, we ran a report today, and for 30 some cases going back to 07, it allows it to go through as a misdemeanor.
I agree.
So the court has done some research to see whether or not the interfering with electronic communications falls into the attempt statute. The attempt statute seems to say that, I shouldn't say seems to say, it says that if the underlying statute in itself contemplates an attempt, then the attempt stand doesn't apply. And I guess when you think about that, there's no such thing as an attempted controlled substance.
Okay.
So the court, I'll be honest, is at a quandary. Either something has changed, which I can't find where it's changed. The computer system all of a sudden just changed, which we can't find that, because the system shows it's been a felony since 01. But again, we've certainly had misdemeanors since then. And if it is truly a felony, that means that while I had the authority to take the plea, it wasn't taken as a felony plea, and I certainly didn't have the authority to sentence on a felony. So
Let me unpack this a little bit.
Yeah.
I too did the same, because I didn't know the background or anything that had happened with your computer system. I was sitting waiting for a jury to come back with a verdict and looked at is what I think you're saying is that statute says that if you enter an attempt, the exposure is half the stated sentence for the completed offense.
generally, there are some circumstances, but generally that's the case.
So it's my understanding that this particular offense qualifies under that designation. So I couldn't figure out, again, my review was cursory. I couldn't figure out where do we go from there. It's like one of those court rules that says you have to do something within 15 days. It doesn't say what happens to you if you don't. It's what I came up with. I couldn't figure out what the so-called remedy was, if you will.
Right. So the attempt statute, for the record, is MCL 750.92. And in there, it talks about that. But then it goes on to say that, let me find it here.
You said 94?
92. So it says any person who shall attempt to commit an offense prohibited by law, and in such attempt shall do any act toward the commission of such offense, but shall fail in its perpetration, or shall be intercepted or prevented in the execution of the same, when no express provision is made by law for punishment of such attempt, shall be punished, and then that's where we get into the half punishment. When I looked at the interfering with electronic communication statute, which is 750.540, in there, I don't see anything that references an attempt, except for the very last clause, which is 7, that says this section does not prohibit a person from being charged with, convicted of, or punished for any other violation of law committed by that person while violating or attempting to violate this section. So the question becomes, does that language of attempting to violate the section now prohibit the attempt statute because it says if that's already contemplated, then the attempt statute doesn't take place? I will be honest, I cannot find any case law interpreting this. And again, we're very perplexed because historically it's always been accepted, but now for some reason, this time it's being kicked back. So my question is this, and Mr. Harrison, you might need some time to talk to your client about it. Do the parties want, and I guess it'd be more so the defense, the ability to look into it to determine whether or not there should be a motion to withdraw the plea or a motion to vacate? Now, we have reached out to Scale and we've reached out to some other courts and had not heard an answer back on the question. We don't know if it's something that just our system all of a sudden made it a felony for some unknown reason.
I would like to know that answer, quite frankly, because if it's a so-called local glitch, that's one thing. If it's, I had no idea. I saw that this hearing had been scheduled. I had no idea why. Well, I just happened to look at it while I was waiting for the jury last night.
And I knew you were in trial. It was yesterday it came up. I knew you were in trial. Mr. Hartel, I addressed the issue with him, so he was aware of it. And Ms. Lawrence was here as well.
Yeah, Rob left me a note. That's the only reason I had any inkling of it.
So that's the issue that we have. Now, I'm not aware of a statute change. I haven't seen where that's changed. So I'm thinking it's a computer glitch because, like I said, historically it's been permitted to go through. But I'd rather err on the side of caution and give the defendant the opportunity to review the scenario. And which it sounds like, Mr. Harrison, you're requesting.
It is what I'm requesting. I'd like to know the quote unquote the answer. I think that's a good idea to pose that question to other jurisdictions or prosecutor, whatever. Just so someone can tell us, here's how it works, or yeah, that doesn't work and you're right, or whatever. Before I make any sort of motion that would be subject to appellate review, that doesn't really help the cause if we can get an answer right away.
Your Honor, if this was a valid sentence, I don't think it's appropriate to allow the defendant to withdraw his plea. So I think we need an answer to whether this is a glitch or there's some area of the law that, because as I read, I did review 750, 540, check for case law. Like you, what I found wasn't helpful. I think it's I don't read that last paragraph as contemplating.
I don't either. And I will say that I came to a dead end. And in an attempt to try to find an answer, I will be honest with everybody, I ran it through the AI on Westlaw. I ran that question through, and AI says it can't be done. But we all know what that means. So, and I've discussed the issue with another judge this morning. And again, historically, that jurisdiction has always treated it as a misdemeanor. But so I'm more inclined to think that this is a computer glitch on our end. But also, I don't want to, you know, if I have wrongly sentenced Mr. Allen and wrongly accepted his plea, I want to make sure that that gets rectified rather quickly.
Yeah, me too.
So, Mr. Harrison, how much time do you think you would need to determine whether or not you need to file a motion to withdraw the plea?
Well, my decision, if you will, is largely predicated on the answer to the question that you've already posed. So I would anticipate you will get a response relatively promptly that perhaps you could forward to me and Mr. Carnes via email, and we could figure it out from there. I would be happy to contact your staff thereafter and say, okay, I guess I'm filing a motion. You know, give me a hearing date. Does that make sense?
It does. I'm trying to think when we followed up with Scale, was it yesterday is when we sent a message to SCAO and have not heard back yet.
Okay. It's a little odd. But it's Friday.
Okay.
They observe Friday in Lansing too, so.
So now the question becomes, what happens with Mr. Allen in the meantime? Do I?
Well, unfortunately, I considered that as well. And I say unfortunately because I could not think of a way that I could justifiably ask for you to release him. Because largely in this situation, the record, if you will, establishes that a sentence has been imposed. And there are, I know the court knows this, but I want to still even flesh it out.
Right.
There are different rules if the sentence is valid or invalid, and that's the question we have right now. So I don't know. The assumption is that the sentence is valid unless demonstrated otherwise in most of the cases. My research was not exhaustive on the topic. It was, as I noted, cursory in nature, but I think that sounds right to me. Obviously, if the court is willing to suspend his sentence pending the resolution of this question, I would happily advocate for him to be released PR, despite the fact that he lives elsewhere in Oscoda. He's never had a problem communicating with me, and he was physically present for the proceedings last week. So I don't believe there's any issue whatsoever if you went down that road as well. I guess that would be my allocution if you asked me what my position was. That's what it would be. I wanted to be honest with you because I believe, to me at least, it's first impression.
Thank you, Mr. Carnes.
Your Honor, the court, I would say, has to be careful here. I don't think we have proof this is an invalid sentence at this time. People v. Fox reported at 312 Mich 577, the 1945 case. Does state that a trial court can't amend a sentence because that would infringe upon the governor's exclusive power under the Michigan Constitution to commute sentences. Elsewhere, the court has recognized, the Court of Appeals has recognized that certain statutes may grant trials post-sentence powers, such as the power to file a written objection to release on parole, but that's contained in a statute. I'm not aware of any statute that would allow the court to adjust the sentence right now. As I look at it, I am all but convinced this is here, but then I don't think it's appropriate to amend the sentence based on how long.
Mr. Harrison, any rebuttal?
I have a rebuttal with Fox's ancient history, it's 1945 case. And it also spoke in terms of commutation, which is certainly a far more drastic measure than what's being contemplated here.
Well, I'll be honest, I've gone back and forth on this situation because the last thing I want to do is keep Mr. Allen incarcerated if it's a wrongful sentence, a wrongful plea. But my reading of the court rules is I have no mechanism because as of right now, because there hasn't been a motion to withdraw the plea, and I understand why that is. You were just essentially made aware of it. I don't believe I have the authority to, as Mr. Carnes would say, suspend my sentence or modify the sentence. I believe I have to make a determination first as to whether or not it was an invalid plea. And I'll be honest with everybody. My intent was to release him, but I don't believe I have a mechanism to do that. Because as it sits, the plea hasn't been challenged, the sentence hasn't been challenged. So as it sits where we are now, it appears to be a valid sentence.
Would it do anything to ease the court's concern if I made a verbal motion to withdraw the plea at this juncture? With the obvious understanding that we may turn right around and re-enter it. But there are a couple of things operating here. He clearly made the plea with at least the understanding and the confirmation by the court that he would be allowed to withdraw the plea if you didn't follow the sentence agreement. I understand what happened in that.
Oh, but it wasn't the agreement just a recommendation of no upfront?
That's
bail?
what it turned out to be, but you did make the statement to him. Yeah, Mr. Allen, you understand if I don't comply with the sentence agreement, that may have been confusion, misunderstanding, misstatement, whatever at the time. And certainly by the time you passed sentence, we had no opportunity to reallocate or anything like that. So it might be appropriate to quote unquote withdraw the plea for other reasons than this particular situation. If that would allay the concerns the court had with regard to releasing my client, I'm willing to do that. But of course, it is subject to notice requirements under the court.
So when I look at MCR 6.310, which talks about the motion to withdraw a plea after sentence, it doesn't seem to contemplate a verbal motion. It says file a motion. I understand where you're coming from, and I'll be honest, Mr. Harrison, I think I remember that. No, I remember that back and forth that I had. So it is possible that there is an issue with the plea taking process in of itself. But I don't think that can be done by a verbal motion. I think that's got to be a written motion.
Which may or may not become academic depending on the other answer we get. I will communicate both with Mr. Allen and the court and vice versa.
Yeah, if we get an answer, any answer I receive from SCAO or another court,
yeah,
if I've got another court telling me that, no, this is a misdemeanor, then I'm going to assume that that's just a glitch in our system.
Right.
So, and like I said, for the last.
And at that point, our analysis would shift to the plea taking process, and that would be appropriate fodder for a motion of that type. So we can approach it that way as well.
Assuming you meet your timing requirements.
Right.
I mean, you only have a certain number of days to appeal.
I'm aware of that, but
but I'm just putting that out there.
I think I could make a good faith argument that based on the uncertainty surrounding it, we didn't even know that it was a valid sentence until X date or whatever, but we'll cross that bridge when we come to it.
Well, I'm talking about the timing for the actual plea taking itself.
Right.
So, okay. All right. Anything else for the record before we adjourn this case?
I have nothing to remember.
Not on behalf of the we are.
All right.
I appreciate the court's sua sponte response to this situation.
We will keep trying to get an answer for it. If the parties do some research, and I know it appears to be a first impression. So, okay, we are adjourned then.
Thank you, Ron.
Thank you.
I will continue as soon as I got it. Okay. Okay. I don't know.
Yeah.
So I'm not gonna do the promise. Okay. All right.
Yep.
The court next calls, the people of the state of Michigan versus Bernard Patrick Porter Jr., case number 252339 ST. Appearances, counsel?
Nick Carnes on behalf of the people.
David O'Meara on behalf of Mr. Porter.
And Robert Hartzell also on behalf of Mr. Porter, who is not with us today, but we did try to reach him.
And I understand that this was set on pretty short notice, so I assume you're okay moving forward without his attendance?
That would be correct.
Mr. Carnes, it's my understanding that we're here for a motion to adjourn. Is it Monday's hearing for a motion to suppress?
Yes, Your Honor.
All right, go ahead.
Officer Howell, has a, training that takes him out of the area on Monday and Tuesday, It lasts all day. He is available starting on Wednesday next week, however. So I would just ask the court to, reschedule the motion for Wednesday, October 8th. I'm just checking the calendar here. It looks pretty wide open, although I did see Ms. Carey just had something.
Morning or afternoon work.
Either morning or afternoon would work for the people.
So you mentioned Ms. Carey, is this her case or your case?
No, this is my case.
Okay.
I'm sorry, I was just seeing she had something scheduled in district court. It wasn't, I guess the court's calendar wasn't as open as I had initially.
Oh, okay, I see.
That's all. So,
All right.
And Officer Howell is the only witness that the people intend on calling for this motion.
And so you said he's in training on Monday and Tuesday.
Yes, Your Honor.
When was that learned?
That was learned by a precise, I think I emailed later shortly after I found out. Tuesday at 3:57 p.m. Tuesday the 30th.
And it looks like the notice of hearing was dated September 10th. Filed with the court the same day. Oh, no, wait, because we've adjourned since then, haven't we?
We have adjourned
Yep.
since then, Your Honor.
Looks like we were here, was it the 19th we were here? Yes, and then we
Yes.
adjourned it to that time. I don't remember why we adjourned, but I know we had adjourned it.
Your Honor, we had adjourned it that day because we had been set for an evidentiary hearing and prosecution was not, I suppose, aware of that and requested an adjournment to get their witness available.
Okay.
I show that we were set for a request for an evidentiary hearing, given that it was a request for an evidentiary hearing, that's why I didn't call my witness.
Is this the one where you were arguing standing?
I was arguing.
Okay.
Yep.
All right, I remember that. Anything else, Mr. Carnes?
No, Your Honor.
On behalf of the people, defense?
Yes, Your Honor. Like I mentioned earlier, at least from the way I understood it, that hearing was supposed to be an evidentiary hearing. Respect if that's not the shared understanding. But in my perspective, this is the second adjournment that we have for a motion that has one witness for the people. Second of all, adjourning it to the 8th would not give enough notice for me to contact my client to make sure that he's going to be here. Mr. Porter is low income. I believe the only way that we can contact him is through snail mail. So, like I said, I would object to this being heard on the 8th if you wanted to set it. You're out until what, the 24th?
16th to 22nd.
22nd. So if you wanted to set it on the 23rd or sometime after then, I would be more willing to stipulate to it, but not the 8th.
Is this set for a final pretrial?
don't think, let's see.
We hold it
No,
over,
it just has a motion hearing on it.
so we're held for the motion.
Consent to being set for a final pretrial as well if the court and people wanted to do so.
We were previously set for a trial, right? October 3rd, and then the motion came in.
Correct.
And then we adjourned the trial to have the evidentiary hearing. And Mr. Hartel, you're going when?
The 16th through the 22nd. We have an office training on the 24th, just so the court is aware for continuing with education.
What does the 10th look like?
10th is you have those two motions on Pruitt and Couples. So I don't know how long that's taken.
Is that a combined motion or separate motions?
They're all set at 2, so I think they're
Mr. Hartel, you represent Mr. Pruitt, correct?
I do, so I will be here at 2 o'clock anyways. Your Honor.
Is that Pruitt and Couples are co-defendants?
Yes, I believe it's going to be a united front as far as the motions.
So a joint motion?
Yes.
Mr. Carnes, are you on that case?
I am not on that case, Your Honor.
And that's another motion to suppress, if I recall correct.
Correct, Your Honor.
So we can set it for, that's at what time? 2?
2. There's motions. It says motion, prelim, and PVs.
Is there circuit court that day
There is, Your Honor, well, morning and afternoon. Yes.
in the afternoon too?
Otherwise, Monday, October 13th is our catch-all day that we're scheduling things in the afternoon. Civil and arraignments.
Will the 13th of October work for the parties?
That was for the people in the.
In the afternoon?
In the afternoon.
That would work for me in the afternoon, but you're quick.
Oh, as far as myself as well, Your Honor, yes, I am also available in the afternoon on the 13th.
You probably don't know about your officer yet, though.
No, he did it, it was my impression that was the only
The only time.
issue. I can obviously see the response now.
All right, well, the court does find good cause to adjourn the motion. And we will set it for right now, October 13th at,
Can everyone do 1 o'clock? So we can do it before our arraignments and civil dockets start.
I'm not sure how much time the people want for their presentation on their part, but I would not be opposed to scheduling purposes.
how much of a civil docket do we have?
Right now, we have 2 formals, 2 settlement conferences, and a motion. And then we have 3 walk-in arraignments.
Civil docket starts at 2.
Civil docket starts at 2. The last thing set is a motion at 3:15. So we could always try it at 3:30.
That's like a motion for summary, I assume.
Yeah.
Mr. Carnes, if we started at 3:30, do you think that would give enough time?
I think it should, Your Honor.
All right, so we'll set it for the 10th. Or I'm sorry, the 13th at 3:30. Anything else?
There you are.
Thank you.
No, thank you.
All right, we are adjourned.